Greetings friends. Welcome to today's current affairs session of Civilspedia. In continuation with the first part of the recent Supreme Court verdicts delivered in the past couple of months, the continuation which we'll be seeing, the topics which we'll be seeing today are decriminalizing adultery, Aadhaar validity, the constitutional validity of Aadhaar, decriminalization of politics. So what is the judgment that has been made by the Supreme Court with relation to the decriminalization of politics, and the landmark judgment of the Supreme Court in regarding the entry of women into the temple town of Sabarimala, and live streaming of the Supreme Court proceedings, which is a Supreme Court order. So all these four are constitutional judgments, meaning interpreting the constitutional judgment, meaning interpreting some articles of the constitution, and this was a Supreme Court order regarding the live streaming of the Supreme Court proceedings. So with this we will be moving on to our first topic, decriminalizing adultery. So already the Supreme Court delivered a landmark judgment of decriminalizing section 377, which was a British colonial rule, and now this is again yet another British colonial rule, which is a section 497 of the Indian Penal Code, which is a colonial code. It has also been struck down by the Supreme Court. So the Supreme Court has got a more liberalized approach in delivering the judgments of section 377 and the section 497. Plus, it has also interpreted Article 21, the right to life with dignity. If we see in the part 1, we have discussed section 377 and how reputation is an important facet of right to life with dignity. In both these judgments as well, Article 22 was interpreted by the Constitution of the India. So let us see what were the comments of the judges with regards to decriminalizing adultery. Before moving on to the comments, we need to know what is adultery. So adultery is a consensual relationship, sexual relationship between a married male and a married female to another married male. So a male can have a consensual sexual relationship with a female of another married male, subject to if the particular male approves the relationship. So it can either be mutual consent or because of the connivance of this particular male. So Supreme Court has struck down this particular clause, telling husband is not the master of wife. So husband is not the master of wife. It means wife and husband are independent even though they are in a marital bonding or a marital relationship. So husband is not the master of wife. And it has also mentioned that section 497 has violated Article 21, which has been deliberated at large in the Triple Talaq case. And these are the two important judgments and the interpretations by the Supreme Court. Now, the Supreme Court has also told that adultery will not be a ground for divorce. This is an already present right. Adultery will not be a ground for divorce. Next thing is, if adultery leads the aggrieved spouse to suicide, the partner can be prosecuted under section 306 of the Indian Penal Code. So the first thing is, adultery can be a ground for divorce. The second thing is, if the aggrieved spouse of that particular, because of that particular consensual relationship goes for a suicide, then the other partner who was in that particular relationship can be prosecuted under section 306 of the IPC. So this is all about decriminalizing adultery. With this, we are moving on to the next topic, the constitutionality status of Aadhaar. Finally, Supreme Court, after a long debate, has constitutionally upheld the Aadhaar Act, which was introduced as the money bill by the Parliament. So it has taken reference from this writ petition on Justice Puttasamy case versus the Union of India, where it has told there is a fair balance between the right to privacy and the right to life. Aadhaar has a fair balance between the right to privacy and right to life. So then there were some restrictions and there were some allowances with regards to the Aadhaar as per the Aadhaar Act. So SC has upheld the Aadhaar by 4:1 majority. We should know it was a 5-member constitutional bench under the Chief Justice of India. So with the help of Aadhaar, Aadhaar is a must, mandatory or compulsory for availing the government subsidies and the government benefits, say the direct benefit transfer, the gas, etc. So for this it is mandatory, and for filing the income tax return the Aadhaar is mandatory. Next, the linking of Aadhaar and the PAN number is also mandatory. So finally it has told there is a fair balance between the right to privacy and the right to life, and there are a large number of services which will not come under the ambit of the Aadhaar, which was previously under the ambit of the Aadhaar. So first one is the educational services, which involves admission of the children and the exam registration of the children regards to education. Second thing was the pensions. So the senior citizens, if they have to collect pensions from the government, had to be linked to their Aadhaar in order to derive the benefits. So this has also been struck down. And the banks cannot compel to link the bank accounts with the Aadhaar to the individuals, private individuals. And they can also struck down the link between the mobile connections and the Aadhaar. So whoever has given their Aadhaar link can take it back if they want it. And to the mobile payment apps and the mobile wallets, Aadhaar has not been made mandatory. And also to the phone connections, credit cards, etc. And there were also some sections of this particular Aadhaar Act which was struck down. One main thing is the authentication records, which need not be kept beyond a period of 6 months. As per the original Aadhaar Act, the authentication records had to be maintained for minimum 5 years. Now, it has been directed by the Supreme Court to be reduced to 6 months. So these are some of the services which are not under the scope of Section 7 of the Aadhaar Act. And this is all about the constitutional validity of the Aadhaar. With this, we are moving on to the next topic, decriminalization of politics. So, when it comes to politics, it is the legislature, executive, and the judiciary. So, when it comes to executive, the political parties mainly stand as candidates to get elected as an executive, or as a legislative member of the parliament or the respective state legislative assemblies. Now, India has a very bad record where 1/3 of the politicians have criminal records. 1/3 of the elected members to the state legislative assemblies and the parliament have criminal records. This was mentioned by the Supreme Court in its verdict. So, Supreme Court intends to interpret the Articles 102 Section E and Article 191 Section E. So, 102 deals with the membership to disqualification of members of the parliament, which is the Lok Sabha plus the Rajya Sabha. And Article 191E intends to disqualification of is regarding the disqualification of the membership of state legislative assemblies and the state legislative councils. So these members can be disqualified only by an act of parliament, where an parliament can make any law to disqualify a particular member. So Supreme Court has clearly told that it is not in their hands to disqualify such persons with criminal records. So it has abruptly given the control to the parliament, which has already been enshrined in the Constitution of India. So some of the comments made by the judges, which was a 5-member constitutional bench, including the Chief Justice of India, are criminalization of politics is an extremely disastrous and a lamentable situation. As we all know, people with criminal records cannot be elected as a representative of the people, where their delivery of public services will be a question mark. And they have also mentioned that 1/3 of the elected candidates are with a criminal record. And it has not given any directions to the Election Commission. Here, this particular appellant had asked the Supreme Court to give directions to the Election Commission to disqualify the members and the political party which has members with criminal records. Supreme Court clearly told that it has no play in the political parties and their elections with the criminal member records. So the Supreme Court has told that the nation is awaiting eagerly for the legislation from the parliamentary side. which is the legislative organ of the government, to enact a law in order to disqualify the members with criminal records. With this, we are moving on to the next topic, entry of women into Sabarimala. So this is regarding women's rights. So already triple talaq, a landmark judgment on the women's rights was announced by the Supreme Court. In line with this, Supreme Court has debarred, struck down the act of the state, of the Kerala state, which initially banned the entry of the women between 10 to 50 years of age, which is roughly nothing but the menstruation age. So it is a physiological disability. Physiological disability as mentioned in the verdict. So the women between these menstruation years are barred from entering into the Ayyappa shrine of the Sabarimala, which is located in the Pattanamthitta district of the Kerala state. So as per the local state law, ban was there. So the Supreme Court has struck down that particular act and has also interpreted Article 25 Section 1 additionally. So here Article 25(1) Section 1 is nothing but the right to freedom of religion, the right to freedom to profess, practice and propagate any religion of choice given to the individuals of the India, which means the Indian citizens. So some of the landmark comments made by the judges, which was a 5-member constitutional bench including the Chief Justice of India, was mere observance of certain practices for a long time does not make it a distinct religion. So since the history of this particular Sabarimala temple, in order to maintain the sanctity of the Lord Ayyappa, women in the menstruation age were not allowed, telling that they are impure because they are menstruating. So this was an age-old practice. Now Supreme Court has said that such age-old practices cannot make that as a particular religion. So here it is a part of Hindu religion and it is something time to time practice which can change time to time. So such practices cannot make it a distinct religion. So it cannot come under the ambit of the religion. This is one point. Next thing is, the alterable parts or practices are definitely not the core of the religion, which was already mentioned here. And it has nothing to do with gender. So it is common to both male and female. Right to freedom to practice, profess and propagate one's religion is common to both male and female. So it has nothing to do with gender. So it also includes the physiological factors such as the menstruation. And entry of ban is a form of untouchability under Article 15. So this amounts to untouchability, which was a comment made by another judge. So thus the entry of women has been ensured by the Supreme Court with help of this case. With this, we are moving on to the next topic, the extension of arrests of activists in Bhima Koregaon case. So we all know the Bhima Koregaon violence happened in the first week of January 2018. So there are two classes in the state of Maharashtra. One is the Marathas and the Dalits. So the Dalits were about to celebrate the 200th anniversary of the Battle of Bhima Koregaon, where the Mahars won. So the Marathas found it as an insult to their pride and they incited the violence. So there was large-scale violence in the entire state of Maharashtra. So now the state of Maharashtra, after 8 months, had arrested 5 activists on the charge that they were the ones who incited the violence. So, with regards to this case, Romila Tapar, a noted historian in India, moved to the Supreme Court regarding the striking down of arrest of these activists and forming a special investigation team. So, this was two points of Romila Tapar made to the Supreme Court. One is to free the arrested activists. Next is to form a special investigation team. And But when this arrest was made by the state government of Maharashtra, the police, Maharashtra police, arrested these activists that they were associated with the CPI, Maoist group of the CPI, which was banned by the government of India. And hence their arrest was made, and under the Unlawful Activities Prevention Act. Unlawful Activities Prevention Act, and they were kept under house arrest. So this was the incident. So all over India, this arrest was viewed as an act of dissent against the government. So all the people were of the view that these activists were arrested since they criticized the government of the day. So with this, some of the comments made by the judges, which was a 3-member judge bench, including the Chief Justice of India, were the activists should be kept under house arrest until the disposal of the petition. This was the first ruling. Second ruling was the refusal to constitute a special investigation team for probe, and the Supreme Court exuded confidence in the proceedings of the Maharashtra police regarding this particular case. So this is all about this case. With this, we are moving on to a SC order regarding the live streaming of the Supreme Court's proceedings, its own proceedings. So until now, only the Rajya Sabha and the Lok Sabha in the Parliament live streamed their day-to-day activities of the sessions, monsoon session, winter session, summer session of the Parliament. And some state legislatures live streamed their proceedings. So it was just the legislatures which did. And now the judiciary is now open to live streaming of its proceedings. So it is based on the recommendations of the Attorney General, Mr. K.K. Venugopal. So the Supreme Court has given nod to live relay its proceedings. So it will usher in more transparency and accountability of the judiciary. When now the entire organs of the government are going digital mode in ensuring the transparency and accountability, which are also public service values when it comes to ethics topic. So this particular move will usher in this both accountancy and the transparency, accountability and the transparency. So for this, some amendments to the Supreme Court rules of 2013 has to be made, and it will be done. So as a pilot project, only the cases of constitutional importance, number 1, and the national importance will be relayed first. And prior written permission from the courts, there are many benches in the Supreme Court, prior permission is required, written permission is required, and if the particular benches believe that a particular content should not be live streamed, then it can strike down its ruling. With this, the topics for today's recent Supreme Court rulings of the part 2 is over. Please do subscribe, link, comment and share the video. Thank you.